matter of Stait and Cosmos Insurance Limited out of Cyprus.
Yes, Mr. Gregor.
My lords, my lady, I act in this matter on behalf of the appellant, leading Mr. Suda, who sits behind me. Mr. Mackenzie acts for the respondent. The way I would propose to deal with my submissions is to deal very briefly with the facts in this case, which are essentially agreed, and the learned judge below may find this about them, which are not appealed. Briefly with the law, as briefly as I can with the law, and then in slightly greater depth with the judgment and the criticisms that are made of the judgment on behalf of the appellant. But I would propose to go briefly through the first two parts.
Well, do it however you wish. I wouldn't have thought we needed to focus a great deal on the judgment. Isn't this one of these cases where there's only one right answer on the facts? Maybe an element of evaluation, but let's see anyway. I don't really mind how you... Just a couple of housekeeping points. My clerk tells me that there were in fact two bundles of authorities lodged. She thinks she's given me the right one, but I just thought I'd better check. Is the correct bundle of authorities one with 238 pages?
Yes.
Right. Assuming the other one doesn't have 238 pages. Secondly, I don't think you... Or maybe this was one of your headings, but I think we are going to want to understand quite carefully the origins of the relevant, exactly which legislative provisions apply and their origins, which means going back to the travaux préparatoires for the Brussels regime. We've looked at the Lenard and Schlosser reports, which weren't in the authorities. I have had copied what seem to us the relevant passages, and they are with the usher, and I might ask you to be given them now. I hope there are 4 sets of each. Usher? Oh, sorry, looking at the wrong person. Thank you.
Thank you.
Yes, I said 4 sets. I'd forgotten Mr. Mackenzie didn't have a junior. Right. As we get to the relevant points, we'll raise them with you. But anyway, you've got them now.
I'm grateful. Thank you very much. Turning then, if I may, to the question for the judge below, which we say he answered wrongly. It's effectively jurisdiction. Was he right to find that the court didn't have jurisdiction over the claim because the claimant wasn't resident in England and Wales at the time the claim form was issued? And we all agree that that was the relevant time which he was looking at. The appellant says that, refining that question down, the correct question was, had the claimant either acquired an additional residence in Cyprus or lost or abandoned his residence in England? So we say the starting point was that he had been resident in England until 2016. What had happened thereafter was the point that the judge ought to have been looking at, and we say didn't. As your lordships, your ladyship is aware, the claimant's an Englishman, he's a member of the armed forces, he was resident in England and Wales with his family until 2016, and none of this is contentious. He was then posted to Cyprus for 5 years. That was not a mandatory posting, if I can put it in those terms. It's a job that he applied for, and the learned friend makes a distinction there between mandatory postings and, as it were, voluntary roles. But in any event, he was posted to Cyprus for 5 years from 2016. He intended always to return to this jurisdiction thereafter, and did in fact return to England in August of 2021. So he was in Cyprus for 5 years. During the course of that, he was involved in a serious road traffic accident on the 24th of October 2017, so the year after he'd been sent to Cyprus. where he was a cyclist and came into contact with a car, sustaining a really serious injury to his hip, which I won't go into, I needn't go into for these purposes. The claim was issued on the 29th of October 2020, so during the course, as I say, of his posting, because he returned in August of 2021. And as I say, we agree that that is the relevant time for our purposes. The facts are set out in the judgment, which is at page 54 of the core.
So we have read this. I mean, obviously you must emphasise the facts you say are important, but you don't just need to tell us, take us to them for the sake of it.
I'm grateful. The important facts that we stress and that the appellant says should be borne in mind from authorities are his intention to return, the temporary nature of his absence.
What do you mean by temporary?
Well, it was only ever going to be 5 years.
So is that any different from intention to return?
It's different in the sense of there was a timescale for return.
Yes, I see.
So it's not a question of somebody who goes abroad and has a nebulous intention. Well,
I get the point. Yeah.
Indeed. So we say that is important, and the nature of his physical absence from this jurisdiction. And by that I mean his familial and other ties were always with this jurisdiction. He didn't put down roots. He didn't intend to put down roots and did not, in fact, put down roots in Cyprus. There is a peculiarity about his position in the sense that as a member of the armed forces, he was resident, or he lived, on the airbase in Cyprus. So he wasn't actually in Cyprus, he was in the sovereign base, which we accept is not part of the UK, but it is a peculiarity which members of the armed forces will all, it's a feature which they will all, or many of them, will exhibit. And that's why we say that members of the armed forces should be treated.
Well, hang on, there might be 2 points there. There's a point about being abroad as a member of the armed forces, which typically means you'll be with a unit of other members of the armed forces and live together as a community. And I see that point, without necessarily saying I agree that it's relevant. Then there's a separate point about the status of the sovereign territories.
Yes.
I mean, you could have the first situation if they were just on an ordinary army base in, borrowed in a NATO country. So are these distinct points?
They're distinct but linked points. So the first point is to do with the community within which he's operating. So he's with another group of people who are also there temporarily. But also, and I suppose it doesn't necessarily follow in all cases, but also he's not engaging with the host community, because as well as being within his own community, he's also within a geographical place, which means that he's not engaging with things like, say, for example, local schools. So his children are going to a school which is not a Cypriot school, and it isn't teaching the Cypriot curriculum, it's teaching the UK curriculum. His wife is living, he and his wife are living with the family geographically, not in the host community. They're living in a separate community. And that, we say, is something that ought to be taken into account, but there's no authority as to that.
Yes, but sorry, the status of the sovereign bases, which how you started this point, why is that relevant?
Simply because it's not the local Cypriot community. It doesn't.
Oh, I see.
There's no. There was at the very beginning something of a hair running that the sovereign base might be part of the UK. It's not.
My lord happened to observe, I think, in a section of the 1982 Act, I think section 52, that there's a power by order in council to direct or to order that overseas territories, including the sovereign bases in Cyprus, should be treated as part of the United Kingdom. But that's never been exercised, is that right?
No.
Yep, I see.
Well, I wasn't quite so much that.
Oh,
It was-
so sorry.
And I'm afraid I haven't chased this point down, but I noticed that under the 1982 Act, that so far as the original Brussels Convention was concerned, there was a power by order in council to make the convention applicable to the sovereign bases, specifically to the sovereign bases in Cyprus. Was there ever such an order in council?
I think I'm right in saying there wasn't. My learned friend might be better able because he did more of the research in the first instance because we'd abandoned that point by then.
My Lord, I don't believe so, and I did look quite hard at first instance. The point, regardless, is a distinction between the UK and part of the UK, and the agreement between myself and my learned friend is even if there were an order in council treating the SBA as part of the UK, it would need to be an order in council treating it as part of England and Wales that she would need to succeed.
No, I'm not on that point at all. I quite understand that you're agreed, and I'm not suggesting otherwise, that it's not part of the UK as such, but that there are ramifications for the various arguments which may interest us, and in particular involving an ability to sue either in Cyprus or in the territory of the sovereign base. And if the sovereign base was made a party to the convention, and if the sovereign base is, subsequent to that, governed by the regulation, although I don't think it is part of the European Union, so it may not have been. But I just speaking for my own part, I would like to have chased down whether it was originally a territory to which the convention was applied, and if it was, it's entirely feasible that it was a territory to which the regulation was made applicable, even though that wouldn't have happened automatically because it wasn't part of the EU. That was my thought process. So if
Right, my lord.
you could come back to us on that, I'd find that helpful.
I'm grateful. I think the answer is no, but I haven't looked at this for some time, so I can't be categorical about that.
Yes, well, I'm sorry I misrepresented my lord's point, but we've got to what the real point was.
Yes.
Yeah, thank you.
I think the answer is that he, in relation to whether or not he could have sued in the sovereign base, there's no court there, or no civil court there, so he couldn't have sued there. But I will chase down, my junior will chase down the answer to that.
Is that right? There's no
I
civil.
thought they
There's several
did have.
courts.
I
Yes,
thought they
we
did
had
have
judges.
that went out there, and they have a perfectly coherent civil and criminal legal system, and it's based on Cypriot law, but it's oddly administered by judges who are sent out from the UK, from England and Wales.
I would check that point as well. I would check that point as well. In relation to the question to be asked then, as I say, the important facts that we stress are the temporary nature of the posting, the intention to return, and the peculiarity of the nature of why he is overseas at the time. And we say that the members of the armed forces are in a special category. The learned friend says in Respondents Notice, well, that's a matter for Parliament. If you wanted to put them into a special category, they could have put them into a special category. We don't go as far as that, but what we do say is that guidance would be of assistance in relation to this category of person, because there will be particular factors in their case, and as I've alluded to, the nature of the community within which they're operating and their lack of engagement with the host community, particularly where you have a geographical area. And as I say, in particular, we rely on the fact that his children are going to schools which do operate under the UK curriculum, so that they can...
But aren't we getting a little bit distracted? Because the DJ held that Mr. Stait's residence was in the SBA territory. Nothing to do with Cyprus, it's in the SBA, which is an overseas territory, as I understand it. So, and I think part of your case is to say he got that wrong. Nobody's suggesting he was resident in Cyprus. So the degree of engagement between the SBA and Cyprus is really neither here nor there, is it? It's just we've got to decide where he's resident. Was it the SBA or was it England and Wales?
I think actually the district judge did think that he was resident in Cyprus.
He conflates the language in places. But,
yes.
I mean, on analysis, it's absolutely clear that he was talking about residence in the SBA, which is physically located on the island of Cyprus, but isn't part of the country of Cyprus.
It may be semantics, but he never talks about the SBA. He does talk about Cyprus as opposed.
I think he does
to
talk about the SBA. As I read it, I thought he used both. But anyway, that's just a footnote.
Well, I mean, for what it's worth, it's at pages. It's at page 57 where he talks about living in Cyprus, and of course he must mean the SBA by that. And then at paragraph 21, similarly, presumably he means the SBA as opposed to Cyprus.
On your case, was he resident in the SBA or Cyprus in addition to being resident in the UK?
Our primary case is that he maintained his residence in England and Wales and never became resident because of the temporary nature of it.
Never became resident outside the UK at all?
Quite. But our secondary case is even if the district judge is right and he was resident on the SBA, he never lost his English residence.
Thank you.
And that's an important issue because as we go through the authorities, I will be, of course, stressing that it's possible to have residence in more than one place and that it's possible for jurisdictional purposes for your residence to be not your main residence or not your principal residence, and that is still good enough. So even if his principal residence was on the SBA, the court would still take jurisdiction if there was a secondary residence maintained in England and Wales.
Thank you.
And so for these purposes, we are looking at, if I could turn to the authorities bundle, it's an Odenbright type claim that's being brought, i.e. it's a claim being brought by an individual as against an insurance company. And that is provided for by the Recast Brussels Convention, which is at page, or the relevant parties at page 11 of the authorities bundle.
So which page?
Page 11.
Oh, sorry.
My page 11, I've got
wrong
Canada
bundle.
Trust.
Right, you've got the wrong bundle of authorities.
I've got the other bundle here. Hopefully I've just had it delivered to me.
I can only apologise for that. Canada Trust was taken out because of the nature of the agreement. We didn't need to take
I've got it. All right, so I'm on the shorter bundle. Thank you.
Right, so page 11. This is Recast Brussels Article 11. Excuse me. An insurer domiciled in a member state may be sued in the courts of the member state in which he is domiciled, and that in this case would be Cyprus, or in another member state in the case of actions brought by the policyholder, the insured, or a beneficiary. And pausing there, there's no doubt here that the claimant's a beneficiary.
Oh, is that right?
No.
Because of the operation of Odenbright, the Odenbright case, FBTO and Odenbright.
Oh, well,
Yes.
maybe it comes to the same thing, but my analysis was we really ought to start with Article 13, oughtn't we? And looking at this is a case of liability insurance. 2, Article 11, apply to actions brought by the injured party directly against the insurer, where such direct actions are permitted. And although it came as a surprise to me because I did my cases a long time ago in this field, since 2003, direct actions against insurers are permitted in this country.
Yeah.
Got that right, have I? Took me a bit of time. So, but it says Article 11 apply, and then you go to 11, and effectively you read it as if 11(1)(b) says an insurer domiciled in a member state may be sued in another member state in the case of an action brought by the victim.
Yes.
But because of the effect of Article 13(2)
Yes.
in the courts for the place where the claimant is domiciled.
Yes.
It comes to the same thing, but isn't that the correct analysis, rather than actually saying he's a beneficiary?
There's a case which isn't in the bundle of authorities, which is FBTO and Odenbright, which is...
Well, I know I was a bit annoyed it wasn't, but I've looked at it. And
Yes.
I think that's consistent with the analysis I just put to you, isn't it?
Yes. Yes. I'm using, perhaps unhelpfully, shorthand. I interpret...
Just don't use shorthand, 'cause it's really quite tricky here, and I think we will want to follow through exactly how all this works.
Right.
But nevertheless, you get to a place where Brussels Recast provides that if you are injured in one member state, you can sue the insurer, the liability insurer in the state where you are domiciled.
Yes.
Yeah.
Yes. I mean, like my lord, I read Edinburgh as saying not that the victim is the beneficiary, but simply that 11.1b must be interpreted as including all those who have the direct right of suit under 13.2.
Yes. Yes. And so that gives a direct right to sue the insurer, which is what's happened here. And whether or not someone is domiciled in a particular place is governed by the law of the forum. So that is then governed, turning back to the Civil Jurisdiction and Judgments Act 1982, which is at page 3. And this is section
The DJ talks about the order, the 2001 order, and you've taken us to section 41. I think the content is the same, but which one's the right one for us to look at?
I think the right one is the 1982 Act.
Can you just help me with that? It provides that the following provisions of this section determine for the purposes of the 1968 Convention. Now, this was an act which had to legislate to make the Convention part of our domestic law, and it did so, and makes provision as to what's then meant in the Convention. But we're not concerned, are we, with the 1968 Convention? We're concerned with the recast regulation made in 2012, I think, and coming into force in 2015.
Yes.
So this section doesn't seem to say anything about what determines the meaning of domicile for the purposes of the regulation. Where do we find that?
That, I think, is in the 2009 regulations, which effectively just replace recast Brussels with Brussels. But I'm afraid that...
Sorry, I'm not quite following that.
So
because the Brussels recast didn't exist in 2009 and didn't come into force, did it, until after 2009?
No.
Was there a subsequent statutory instrument that said what the interpretation was to be for Brussels recast, which is what we're concerned with?
There is a regulation which I cannot give you off the top of my head. I don't know whether...
It may be of some assistance to look at the judgment in the Bestowell case at page 101. This is Simon Bryan QC as deputy, now it's Justice Bryan. That quotes in full the relevant portion of the 2001 order.
Thank you.
It is, I should say, identical text.
Sorry, just forgive me, just take me to that. Which?
Page 101 in my bundle, it's paragraph 22 and 23 of the Bestowell judgment.
I'm very grateful to learn a friend.
Does the 2001 order, well, the 2001 order predates Brussels recast? Do we take from that just that doesn't matter because the order sets out what the rules are in national law?
Yes. Now we can do a deep dive into this more, but we don't have...
Well, I would be surprised if there isn't some provision
Ties it
in the order that ties it to the Brussels regulation, not Brussels recast. If it was a 2001 order.
My lord is a master of this area and I'm not. It's possible that the way the 2001 order is framed, but we need to see the whole thing, means that it applies even if, applies even to Brussels, even though Brussels recast is subsequent to it. But we'd have to see how it was worded.
Yes.
If it said specifically it was referring to the previous regulation, then you'd need another order applying it to Brussels Recast.
Yes.
I think
I've got the order. I've got paragraph 9 of it here. It does refer to the regulation, which must be the older regulation because it's a 2001 order.
Yes.
So for purposes of the regulation, this is how you deal with domicile. So there must be something
There must
that
be an
updates it.
amendment. Yeah, there must be. I'm afraid I don't know the answer to that.
no. Well, that's very frank. I mean, but I think we do need to know the answer
Yes.
to that. You were lucky enough to have a junior who may even have a computer, so you may be able to get the answer while we're here. But I think we will need. We should proceed on the basis that the provisions are what everyone thought. Well, the substance is what everyone thought it was. But I think we need to know the route by which we get there.
It may be helpful if we produce an agree between ourselves and produce a supplementary bundle which contains FBCA.
I think that would be useful, but I mean, better still, we were hoping this wouldn't go all day, but it will certainly go into the afternoon. If you're lucky, without having a nice, neat bundle, we can at least be given all the references after lunch. If it takes longer, then so be it.
Yes.
So don't just regard it, because for all I know, I hope not, that may raise further questions.
Yes.
So I think we would like to be able to bottom it out in this hearing, unless that proves impossible.
Yes.
Okay.
I mean, there is an answer, and we will reach it before the end of the day.
Yes, I mean, I don't know whether this is the time, since we've interrupted your flow, to say this is why the travaux préparatoires are potentially relevant, because it is clear that whatever piece of English or UK legislation it is, it was deliberately introduced because while the Brussels Recast says, as its predecessor had said, that the definition of domicile was to be for the internal, the law of the relevant member state, they didn't like what the result that would produce in UK law as they then understood it. And there is a recommendation in the Schlosser report, or I may be confusing my two reports, that for that very reason, the UK change its internal legislation to legislate specifically for this case, to bring its understanding in line with the broad spirit of the law of the other member states, while recognising the law of the other member states might still differ in detail. And that's what we see in, just give me one moment.
It's paragraph 73, I think, of Dr. Schlosser's report.
Yes, we've got, is that one? I hope I copied that.
Or Gennard. It's Gennard, I think.
Well, yeah, I think the position is it's pages 15 and 16 of Gennard which set out the different rules on domicile amongst the then member states, which of course did not then include the UK. And it's Schlosser, paragraph 71 to 73, and paragraph 73.
Yes, I'm sorry. I think I have confused matters. This was just I wrote Gennard on the top of the extract from Schlosser. They're both extracts from different parts of Schlosser. Sorry about that. Yes. It's the paragraph saying the working party therefore requested the United Kingdom and Ireland to provide in their legislation implementing the 68 Convention, at any rate for the purpose of the Convention, for a concept of domicile which would depart from their traditional rules and would tend to reflect more the concept of domicile as understood in the original states of the EEC. I did this copying at rather short notice, as you can tell.
Yeah.
So by all means, check it for yourselves and look at the full reports. But that is the passage which my Lord and I particularly had in mind, though other passages are relevant as background.
And you will find in Gennard, at pages 15 and 16, a summary of what the different concepts were of domicile within the then member states, which is what the
I
UK
think
were
actually-
invited to approximate their...
I think that may be the extract which I've marked Schlosser.
Right.
But anyway, I think it's important. It may, at the end of the day, not be decisive, but I think we need, in interpreting this piece of UK legislation, to understand the full legislative history and why we got to where we are, and that's why I think we will certainly want to refer in our decisions to the travaux préparatoires, and you need to look at them and see to what extent there are any suggestions you want to make about them.
May I have a moment to read them now? Because that may assist. Or
By all means do, yes, if you, yes. Entirely up to you, but if I were in your shoes, I might say that no doubt Mr. Mackenzie will be feverishly looking at them if he hasn't already. Your junior will be, and that you'll deal with it at a later stage if necessary to reply. But if you think you can say something useful on the basis of a quick read of it, please, I won't stop you.
Can I just cast my eye over it? Because
Yes.
I want to get the headlines as to
Yes.
what is concerning the court about this.
Well, look, I certainly think you should look at 72 and 73 of Denard, of Schlosser.
I'm grateful. If I may, I will address you in relation to those in reply.
Probably a more prudent course, yes. I'm myself, I'm not making any particular point about them. I just think that with any exercise of the kind we have got to do for the purpose of this case, you've got to go back to the beginning and understand the legislative history and why. That clearly is the origin that produced the provisions that we're now seeking to apply.
Yes.
And that casts some light, maybe not decisive light, on how they should be approached.
It does. The only note of caution, and I actually don't know whether this goes for me or against me, but the only note of caution I would sound at this stage is that although the Working Party may have been concerned about UK internal law, it may be that we didn't change our law in consequence of what the Working
We plainly did. We plainly did, because at common law, our concept of domicile was very different from what's in these instruments. You had a domicile from birth, initially your father's domicile, or if you were illegitimate, your mother's domicile, and then you could change your domicile voluntarily, but it had to be voluntary, and it had to involve choosing somewhere else to live either permanently or indefinitely. And if you chose to go and live somewhere only temporarily, you didn't change your domicile, and you could only ever have one domicile. You couldn't be domiciled in two different places. So those are all aspects which have plainly been changed by the Section 41 and the statutory instrument we've been looking at. So it seems to me, at least, that there was clearly an acceptance of the invitation to change what domicile meant for the purposes of the Convention and the original Brussels regulation, and that the request to do so was taken up.
Yes, and in relation to companies.
Well, let's not
Yes.
confuse ourselves about companies. That's a different matter. But I mean,
let me address
you
that
won't
if
need
I
this,
may.
I'm sure. But it's all extremely clearly set out in Chapter 6 of Dicey and Morris, different concepts of domicile and residence.
Yes.
Yeah.
So in relation to residence, domicile is residence, but not habitual residence. And there's a distinction because in some of the cases they talk about both, say for example Levine talks about both residence and habitual residence, but what we're looking at here is residence, not habitual residence, which may be a distinction which is important. In relation to the burden and standard of proof in this case, that's covered by the Brownlee case, which in my submission removes something of a gloss that had been placed on the arguable case question, because it had been said that I would need to show that I had much the better of the argument. And in my submission, Lord Sumption in Brownlee suggests it's not much the better of the argument, it's just the better of the argument. So it's a lesser test than the balanced probabilities, for example. And that's to be found in the authorities bundle at page 172, where Lord Sumption turns his mind to the test, which had until then been set
So, do you want us to look at this?
Sorry?
Are you taking us to?
Oh, please.
Yes. So, which page in the bundle?
So 172. And it's accepted that the burden of proof falls upon me as the person establishing residence. But the question as to what I have to establish, I say, is a good arguable case. Not a much better argument, but a better argument for what it is worth. And that is a lower standard than balanced probabilities. So at the bottom of 172, he says, in my opinion, it's a serviceable test, provided it's correctly understood. The reference to a much better argument on the material available is not a reversion to the civil burden of proof, which had previously been rejected by the House of Lords. But what is meant is that the claimant must supply a plausible evidential basis for the application of a relevant jurisdictional gateway, because he's talking about the CPL Part 6 gateways. And so on. So what they have to prove. He says, I don't believe that anything is gained by the word much, which suggests a superior standard of conviction that is both uncertain and unwarranted in this context.
I'm not. You may well be right about this, but I mean, A, Lord Sumption was in the minority, wasn't he? And B, in any event, everything said in Brandy 1 was obiter.
Yes.
So is this confirmed in Brandy 2?
It's not addressed in Brownlee 2, but in my submission it is in any event unhelpful to look at much the better argument, because that elevates the burden of proof as if it were more than the balance of probabilities.
It is, I think, now thought of as the orthodoxy, replacing much the better of the argument.
Yes.
But for my part, I'm having some difficulty in seeing quite why you're taking us to these passages. We've got the evidence.
Yes.
You bear the evidential burden of proof. The evidence is what it is.
Yes.
The question of law it may be what is meant by residence for the purposes of the relevant instrument interpreting the Brussels Recast Regulation. That's a matter we have to decide, right or wrong. It's not enough for you to say it arguably means this or arguably means that. And then we have to apply whatever that meaning is to the evidence. And again, there's not much room for arguability there.
No.
Is it? We simply have to decide whether applying the right test, the facts as you've put them before the court, mean that he was or wasn't resident at the relevant date.
Yes.
So I'm not really quite sure where arguability comes into it.
I think if you were to decide it was a borderline case because the factors are very well balanced, it might make a difference in such a situation. I say it's not a situation like that, but simply the correct test is not much the best. It is the better.
But it isn't a test, is it, of whether either much the better arguably or merely arguably the facts are such as to make him resident. The question for us is, do the facts make him resident?
It is. I think the district judge approached it in a slightly different way, though, in the sense that he doesn't seem to have accepted, for example, the intention to return as having been proven. And we say, well, actually, that is proven. And
we can have a look at that, but I mean, speaking for myself, it's obvious there was an intention to return.
Yeah.
The question is it relevant?
Yes.
That comes back. I rather doubt at the end of the day whether, following the twists and turns of every point in the district judge's argument, is simply how this appeal gets decided. As my lord said, we've got the facts. Once we've decided what the law means, there's probably only one answer.
Yeah.
You could imagine a marginal case, in which case we would have to respect the decision makers, first-time decision makers' evaluation. At that point, it might be relevant to see if he'd misdirected himself. But speaking for myself, I don't think this is marginal once we've understood what the facts are.
My lord, yes, I'll move on.
The law is, I should say.
The first authority is Levine, to which I would like to take you. It's at page 13 of the authorities bundle. It's a tax case, but it has been treated in all of the authorities as founding the consideration of the principles which apply when one is considering residence. And this looked at resident and ordinarily resident, and we're only concerned, of course, with residents. And it is from Levine that many of the principles are derived, which run throughout all of the authorities to which we will be taking your ladyship today. And the first thing to be said is at page 18 of the bundle of authorities, about 2/3 of the page down, where it is said, my lords, the word reside is a familiar English word and is defined in the Oxford English Dictionary as meaning to dwell permanently for a considerable time, to have one's settled or usual abode, which I would emphasise, to live in or at a particular place. They go down to speak about the tax schedules and then go on. In most cases, there is no difficulty in determining where a man has his settled or usual abode, and if that is ascertained, he is not the less resident there because from time to time he leaves it for the purpose of business or pleasure. So a master mariner who returns to his home during intervals between sea voyages has been held to reside in the family home, although he actually spent the greater part of the year at sea. So that establishes one of the principles to which I'll take you later in Bestelov, which is to do with leaving for parts of the year and returning, and it's where you have your home, as it were. And then over the page at 19, a couple of inches down, a man may reside in more than one place, and this is an important principle for our purposes. Just as a man may have two homes, one in London and the other in the country, so he may have a home abroad and a home in the United Kingdom, and in that case he's held to reside in both places and to be chargeable with tax in this country. So although Levine is to do with tax, it also establishes this principle of the possibility of two residences, which does follow through in the rest of the authorities. And then there are examples of other cases. And then at 3, the above cases are comparatively simple, but more difficult questions arise when the person sought to be charged has no home or establishment in any country, but lives his life in hotels or at the houses of friends. If such a man spends the whole of the year in hotels in the United Kingdom, then he is held to reside in this country. For it is not necessary for that purpose that he should continue to live in one place in this country, but only that he should reside in the United Kingdom. But probably the most difficult case is that of a wanderer who, having no home in any country, spends a part only of his time in hotels in the United Kingdom and the remaining and greater part of his time in hotels abroad. In such cases, the question is one of fact and of degree. It must be determined in all the circumstances of the case. If, for instance, such a man is a foreigner who had never resided in this country, there may be great difficulty in holding that he is resident here. But if he is a British subject, the commissioners are entitled to take into account all the facts of the case including facts such as those which are referred to in the final paragraph. So, my lords...
Sorry, which is the final paragraph of the case stated?
I think it's at the bottom of 16 and top of 17.
I believe, in fact, Lord, it's a reference to the quotation at the next page, to the bottom of the case stated, I believe, ends at top of 18. That's the quotation from the Commissioner.
Quite right. Yes, quite right.
So the points to be derived from this part
Thank you.
of Ravine is that it's possible to have two residences. There are different considerations where a person is an Englishman and has been subject, has been a British subject, and has been living in England, effectively. Because we're looking, for our purposes, not at the UK, but at the part of the UK. And our claimant is English, was living in England until 2016, actually has property.
Those observations are made in the specific context of what Lord Cave calls a wanderer.
Yes.
Which was the facts of Mr. Levine's case.
Yes, but these comments are then read over into the additional principles which we see in, for example, Veselov a little later. But this is the genesis of them. And it is relevant to note that in our case, the claimant has a property here which he's rented out in order to go and take up the posting on the airbase. So he does have a property within England, but he has gone for 5 years elsewhere, but intends to return. So although not apt to describe him as a wanderer, his absence is certainly temporary, we say. Turning to page 21, the court turns its mind to ordinary residence, you see in the highlighted part. And says, I think it connotes residence in a place with some degree of continuity and apart from accidental or temporary absences. So understood, the expression differs little in meaning from the word residence as used in the Acts. I find it difficult to imagine a case in which a man, whilst not resident here, is yet ordinarily resident here. The point to be made about that is that there is a reference to an acknowledgement of accidental or temporary absences. And we say, this is not an accidental absence, but it is a temporary one, because we say that the nature of the absence is such that it is clearly temporary, because, as I said earlier, it's time limited, it's only for 5 years, which is a short period of time comparative to the rest of the claimant's life, which has been spent in England.
But that's a function of the length of time as well as merely the fact that it's temporary, is it?
It's, yes, both.
If a young man says, I'm going to live and work in France for all my working life, but I'm going to keep the house I've just bought because I'd like to retire here, that would be different, would it? Because of the length of time, even though his period in France would be temporary.
Yes, it's a question of fact and degree, and I think in such a circumstance, my argument would be more difficult to make.
Working lifetime sufficient, 5 years not sufficient.
Yes, it's a question of fact and degree compared with the life that had been spent previously in England. So if a person has spent 60 years in England and says, well, I'm going to spend the rest of my working life in France and then I'm going to come back to England, then that, I say, would be different in character to a person who at the age of 20 says, well, I'm off to France and I'm going to spend twice as much time in France as I have already spent in England and then I'll return.
So if Mr. Stait had been posted abroad for 5 years soon after he joined the Royal Air Force, and he said, I don't know where I'll come back in 5 years, but I don't know where I'll go next.
Well, in my submission, 5 years would still be too short in such a circumstance. But if you had 15...
But compared with the rest of his life, on my hypothesis, he would have had a very short period living here as an adult with a home here, and he would have an uncertain period thereafter. So 5 years might seem quite a substantial proportion of the time to be definitely spending elsewhere, compared with merely a year and possibly no more here.
I think there are two factors there. First of all, he would have spent not just his adult life, but also his childhood in England, which would count.
Right.
So it's still 5 years versus 18, for example. But also, in that hypothesis, there is no settled intention to return to England and stay here. Whereas in our case, he's returning to England, he's still here.
Is there evidence he had a settled intention to stay here then permanently?
Yes.
There's evidence he was never going to take another posting abroad.
There's no evidence either way on that,
No.
but he does say his children are coming back because they're going to come back to school in England. So certainly his family is returning. And he and actually we know that he does, and he's still here. But in your lordship's hypothesis, there is evidence that he's going to go away again. So that's slightly different.
Okay. Thank you.
So at page 22 then, and this is the point about how long do you take into account when you're looking at residence. At the bottom of page 22, the final paragraph, excuse me, it suggested the commissioners misdirected themselves in point of law because they took into account, with regard to the earlier years, conduct which only occurred subsequently. I agree the taxpayer's chargeability in each year of charge constitutes a separate issue, even though separate years are included in one appeal. I do not think any error of law is committed if the facts applicable to the whole of the time are found in one continuous story. Light may be thrown on the purpose with which the first departure from the United Kingdom took place by looking at his proceedings in a series of subsequent years. They go to show method and system and so remove doubt, which might be entertained if the years were examined in isolation from one another. The evidence as a whole disclosed that Mr. Levine continued to go to and fro during the years in question, leaving at the beginning of winter and coming back in summer. His home thus remained as before. He changed his sky but not his home. And in my submission, that is where we are in this case. You look at the whole of the story, the whole of the picture, not just in 2016 he was posted to Cyprus and immediately took up residence there. You look at all of the whole pattern of his life prior to 2016 was that he was based in England. Everything about his life is based in England, was before that and remains based in England. His property, his investments, his voting pattern, medical treatment, everything is based in England. And I say that you can take that into account because you look at the continuous story. And if you do look at the continuous story here, you see a man who is always resident in England, goes for 5 years and returns.
I understand. I'm sorry to interrupt you again. I'll pause while you consider your junior's note.
Yes, I'm sorry, my lord.
Whereabouts in England was Mr. Stait resident between 2016 and 2021?
I say that I don't need to show a property address, but if I do, it's Cumbria because he does have a property. But I say that it's not necessary to show a property address if the authority of Chowdhury is right, which is a High Court authority which is in the bundle. You don't need to show a property address. And the reason for that is that some people don't have property. And actually, some of these cases are to do with people who live in hotels. Some people live in hotels. You may find a homeless person. You may find a peripatetic worker. They wouldn't have any jurisdictional rights if they have to show an address within the jurisdiction.
That's a slightly different point. That we've already seen from what Lord Cave says. It doesn't have to be a single place.
Yes.
So you can establish residence by living in different places, but all of them being within England.
Yes.
So when I ask you whereabouts in England was he resident, I'm not asking you necessarily to say there was a single place, but which place or places were the places in England where he was resident during that period?
Well, the Cumbria, there is a property address in Cumbria.
Very odd to say he was resident in Cumbria during this period when he never went there, never stayed even a night there.
Well, I say you don't need physical presence for residence. because if you did, you could never, it would be impossible to have two places of residence because you can never be in two places at once. So the fact that it's possible to have two residences shows that there doesn't have to be a physical presence.
Well, I'm not sure that's right. Take a year in which you spend half your time in England and half your time abroad, a classic two residences situation. You would have a physical presence in your English residence in the first half of the year and your French residence in the other half of the year. But here, there's no physical presence at all in England in the 5 years in question.
Apart from wherever he spent his weeks on holiday.
Yes, but my lord, it's possible to have two places of residence at the same time.
Yes.
Not one after the other. So if it's possible to have two places of residence at the same time, it must not be a prerequisite of residence to be physically present in that place.
On any one day, that is obviously right, but the fact that on day one you were in one of your two residences doesn't negate the fact that the other residence is there and is available to you and is your other home.
Yes.
Residence is determined by looking at the position over a period of time, not the scintilla temporis when the claim form is issued.
Yes.
But that does not mean that residence in that wider temporal set can be established somewhere without spending any time there, does it?
It depends. The answer to the question will depend what period of time you look at.
Yes.
Because the appellant's case is that he had been physically present in England until 2016. So if you look, as I invite you to, at the whole of the course, there is a physical presence, and it is a...
Well, I understand you say if you look at the period of time which takes account of the period of time before he went to Cyprus, he was present here and he was in his house in Cumbria. You were on a slightly different point, which was, in answer to my question, looking at the period he was away, he could be resident here without being physically present here at all.
Yes.
That's what I'm having a little difficulty with, I'm sorry.
Yes, in the same way that in the oligarch cases, these are men, and it is mostly men, who move around a great deal. They might stay in hotels. And actually, Levine was a case where he was staying in hotels. So as soon as he leaves the hotel, as soon as he checks out of the hotel, he doesn't then have a right to stay anywhere. But that doesn't mean he's not resident within this jurisdiction.
Yeah, but his pattern of life there, it is actually, I think it's Levine, rather than the oligarch cases, they mostly do have a home here, even though they don't go there very often. But Levine is your best case from that point of view. As you say, it's the Savoy 1 week and the Dorchester the next. But his pattern of life, nevertheless, is when he's in England to stay in a hotel, and that is on that basis, London is his residence.
Yes. Again, I think it depends where you chop the period of time off that you're looking at. And I say you look at it across the 2006, across the whole period of time. And if you do,
I entirely understand that.
yes.
I do find it difficult to say, once you've chosen what the relevant period of time is, someone can be resident in a place where they are not physically present during that time. And are you really making that submission? That's what I'm asking you.
Well, yes, in the sense that there is a physical presence across the period of time, and it's the same with the oligarchs, where they're not here all the time; they're here some of the time, and we tend to look at, or in oligarch cases, you tend to look at they're here for 22 days in the year, for example. Mr. Stait not only has a property, so he's an occupier here throughout because of the property in Cumbria. It's rented out, but he has the freehold of it and he rents it. He's a landlord. not only does he have that property throughout this period, but also he is returning, and he is coming back once a year, which the judge sort of slightly sniffily dismisses as being a holiday, but he's coming back once a year and seeing his family and returning to his home. And he does say in his witness statement...
When you say returning to his home, you mean returning to his home country?
Yes. Yeah. I mean, if you ask Mr. Stait where his home was, he would say England. And he does say in his witness statement, our time in Cyprus was always going to be temporary. We knew we'd be returning to the UK, so we kept our house. So he ties himself to his house that he knows he'll be coming back to after this temporary absence. So although I say you don't need a proxy, but if you do, it's the house. And he is also physically present in other locations when he comes back during the period of his posting. And of course, COVID-19 does affect that to some extent over the time period that we're looking at.
Is there any evidence about that?
Well, we issued in October 2020, and he says in his witness statement somewhere that COVID-19 did affect his ability to return.
Well, it must have affected his ability to return in effectively the previous 6 months.
Yes. Not before that, of course. But there is a disturbance in what he's able to do at that time. But the point remains that he's got throughout this period, even from the 2016 period, he's got a physical presence in this country, and it is his property which he owns. And also, he himself has a physical presence in this country when he returns.
Okay, I mean that's been helpful, but we rather spun off from where we were,
Yes.
That's how it always goes. But is there anything more you need from Levine? We've looked at the speeches of Lord Cave and Lord Sumner.
Just from Lord Warrington to do with intention. This is at page 27, and it's one of my learned friends' points. I think that intention is irrelevant. I say intention is very important. Actually, it's an important factor, and it seems to have been taken account by Lord Warrington and Levine at page 27. It's a very long paragraph, about a third of the way from the bottom, where they talk about Monaco and France and England, living in hotels. The appellant states that he intended throughout to live abroad, but his intention does not appear to have been a very pressing character. Although he made in the course of the years 1922 to 1924 endeavours to find a suitable flat, he didn't succeed until January 1925. And so he appears to have considered intention as being important. I will return to that point in other cases. And then over the page at 28, just finally on Levine, the first paragraph, but towards the end, if it has any definite meaning, I should say it means according to the way in which a man's life is usually ordered. And the appellant's case is that his life is usually ordered such that he is resident in England. And I pray and aid in support of that submission the fact that things like he's got an English registered mobile phone and all of the other perhaps subsidiary matters. He's on the Electoral Registry in England and has an English GP. So that's Levine, which...
if you're in a place wait on that, what's the test for being on the Electoral Register?
I think it's residence.
I'm not going to take this very much further. Even if it is residence, A, we don't know what residence means for that concept, and B, the fact he chooses to represent himself as resident in the house in Cumbria, how would he do that?
I strongly suspect that there are some special rules for members of the armed forces.
Well, that may be the position. But I think, put it this way, if you actually want to place weight on that particular factor, you can't really do it without showing us exactly what the rules are.
I'm not placing weight on it to show that somebody else has considered him to be resident here. I'm placing weight on it to show that he has a desire to be on the Electoral Register here. So he has taken steps to place himself on the Electoral Register. he has an interest in voting here. He wants to vote here rather than anything else. Now, Levine was a tax case, but it has been taken as founding principles in this area, and that was acknowledged in the Bank of Dubai case, which is the following authority. I needn't take you to it, but the relevant part of that is page 33 of the authorities bundle, where it says, well, although Levine was a tax case, we are having regard to it, but that's simply the way in which I rely on the Bank of Dubai case. Davis, then, I say, is the next important case in the bundle of authorities. Now, Davis is also a tax case, but we know from Bank of Dubai that the fact that Levine was a tax case doesn't preclude us from looking at it in relation to residents. And I do rely on what is said in Davis. And if I turn first to page 45 of the bundle of authorities, this is paragraph 14. Now it says since 1928, and that's a reference to the Levine case, which His Lordship has just been discussing. If not before, it's been clear that an individual who has been resident in the UK ceases in law to be so resident only if he ceases to have a settled or usual abode in the UK. The phrase "a distinct break" first entered the case law in a subtly different context, but it's now much deployed, including in the present appeals. It's not an inapt description of the degree of change in the pattern of an individual's life in the UK, which will be necessary if a cessation of his settled or usual abode in the UK is to take place. And I say that that is a useful signpost to what would have to be negated, because the burden of proof remains on me, but what would have to be negated in this case, a distinct break. And I say that the 2016 posting is not a distinct break in his settled pattern of life because of the temporary nature of it. Turning to page 47.
I just noticed passage hasn't been sidelined. Section 334. Every Commonwealth citizen, does that include a UK citizen? It doesn't matter for the point I wanted to put to you. Shall, if his ordinary residence has been in the United Kingdom, be assessed and charged to income tax, notwithstanding at the time the assessment is made he may have left the UK, if he is so left for the purpose only of occasional residence abroad. Doesn't that suggest that but for section 334, going abroad for occasional residence means you're no longer a resident in the UK? In fact, it's subject of special provision. It's rather like the point that, as I understand it, you've only given us parts of the provisions. Under the Taxes Acts, people posted abroad in the service of the Crown have to be the subject of special provision. The inference being that they've lost their residence here, but for the special provision, by being resident abroad where they've been posted. Sorry to dump, it's really a hook for that point, I suppose.
Yes, I mean, for tax, because there are particular rules for tax purposes which relate to number of days abroad, they would have to make specific rules for people who are posted and who therefore spend no time within UK at all. Because otherwise their difficulties would arise because they would be outside the jurisdiction, completely outside the jurisdiction for, some years. So one can see why there would be particular tax provisions made. to deal with that specific circumstance. Turning then to page 46, this is relation to the distinct break point. And this is to do with numbers of days away, person who stays in hotels.
So sorry, I was just writing a note. Where are you taking us to?
46.
46.
And at the very bottom of the page, there's reference to there being a distinct break in residence. And that is then further explained over the page as to what that means. And what's required to be broken is the pattern of the taxpayer's life. And I say that you can read that across from the tax cases and say, well, if he has been in England and Wales all the way up to 2016, there would need to be a distinct break. There would need to be a break in the pattern of his life. And I say that the pattern of his life is demonstrated by the fact that his bank accounts in England, property and investments, you've seen the factors, I won't repeat them.
You say pattern here means, that doesn't really mean physical location.
No.
It means all the connecting factors other than physical location.
Precisely. And there's then consideration of what that means. In the following paragraph. It says the controversial references in the judgment of Moses L.J. in the decision under appeal to the need in law for severance of social and family ties pitch the requirement at any rate by implication at too high a level. So you don't need to show that they've completely turned their back on the jurisdiction. The distinct break relates to the pattern of a taxpayer's life in the UK, and no doubt it encompasses a substantial loosening of social and family ties. So there doesn't have to be a total break with the jurisdiction, but there does have to be a loosening of social and family ties. But the allowance to which I refer of limited visits to the UK on the part of the taxpayer who's become non-resident clearly foreshadows their continued existence in a loosened form. Severance of such ties is too strong a word in this context. So it needn't be shown that Mr. Stait has left evincing an intention never to return. He's never going to speak to anyone in the UK again. But there does have to be a loosening of the ties that bind him here. And I say that in this case there is no such loosening of those ties because he maintains the property, he returns, he maintains the familial ties. And what he says in his witness statement is that, you know, I've learned a couple of words of Greek to get by, but actually I'm not really operating in the community. And that comes back to the point that I was making earlier about the particular nature of the armed forces and their lack of engagement with the local community.
Can I just focus for a moment on social and family ties? Presumably before he was posted to Cyprus, his primary social non-family ties were friends and no doubt colleagues with whom he spent his time in barracks, outside work time and so on. And his primary family ties were presumably his wife and, did he then have children? I've forgotten. Yes. Those would be his. Now all those moved to Cyprus with him. Those primary social and family ties, didn't they?
Well, his wife and children do, but
Yes.
the rest of his wider family don't.
No, but if we're looking at family ties, he has, before he goes, he has his close family ties with his immediate family, wife and children, and he has wider family ties. And what happens when he moves, if we focus just on family ties, is that his primary family ties move to Cyprus, albeit that his more remote family ties stay in the same place. Now, is that what would be described as a loosening of family ties with this jurisdiction?
No, because he's still maintaining the secondary family, as I would describe them, secondary family ties.
But if you look at the basket of his family ties, the major part of them, if I can put it that way, has been severed from England. It's gone with him to Cyprus.
No, but this is a slightly different point, I think, if I may say so, because what this is looking at is someone who has left family here and looking at the ties between the person who has left and the people who remain. There's no loosening of family ties with his primary family because they've gone with him, but that's not a factor that factor's neither here nor there, if I can put it that way, because that doesn't evidence.
We're not looking at loosening of family ties in the sense of changing the relationship. We're talking about loosening the family ties with the particular jurisdiction.
Yes, precisely.
And taking his wife and children with him does loosen those family ties to this jurisdiction, doesn't it? I mean, it removes them.
Now. Yes, I take your lordship's point now. It means that they're no longer physically present here, but the children continue to have ties to this jurisdiction because they are being educated in this jurisdiction's curriculum by UK qualified teachers. So actually the children, where they spend most of their times at school, and what they're doing is determined by this jurisdiction, because what they're learning is determined by this jurisdiction, and the people who are teaching them are qualified in this jurisdiction. So actually the children haven't loosened their ties at all. Now, there's no evidence of the wife's occupation, whether or not she had a job, for example. But the family as a whole, the husband and wife, Mr. and Mrs. Stait, had always intended to come back. They knew they were coming back. Her home, her property, is also in Cumbria, so her ties remain to this jurisdiction in exactly the same way that his do. She's not loosened her ties with this jurisdiction in a voluntary way. She's gone with him, so she's dependent on him. And the children, as I say, don't loosen their ties at all, clearly. And then the only other part of Davis to which I would draw your ladyship's attention is page 60. And it's paragraph 63D. The underlying principle the law has established is that it must be shown there's been a distinct break in the pattern of the taxpayer's life in the UK. The inquiry that this principle indicates is essentially one of evaluation. It depends on the facts. It looks to what the taxpayer actually does or does not do to alter his life's pattern. And his intention is, of course, relevant to the inquiry, but it is not determinative. I simply take you to that part to negate the suggestion that intention is irrelevant, which is part of the respondent's notice.
Have you done with this case? I wanted to ask you a question about an earlier paragraph. Could we go back to paragraph 21, just to pick up that point? So you took us to paragraphs 19 and 20, but what Lord Wilson goes on to say in paragraph 21 is to talk about somebody who's employed abroad full-time. And as I read that paragraph, he thinks it's a very easy proposition to say that somebody who's employed abroad full-time does create a distinct break with the UK. So I just wanted to understand what I think your answer to that would be yes, but Mr. Stait is not employed full-time in the ordinary employer-employee sense. He's sent abroad by the forces, and we get back into the sort of the quality of his time abroad.
Yes.
Yeah?
Yeah.
But it is right that a lot of what you've said needs to be put in context that Lord Wilson was absolutely envisaging somebody who might be sent abroad on work for 5 years as being somebody who was no longer resident in the UK on ordinary principles, which is why you needed IR20.
Well, that, but also he doesn't talk about it being temporary. So there's no reference there to he's going for 5 years or he intends to return. So
It's not so much temporary. In a sense, in most cases, it's temporary in your broad sense of temporary. If someone's sent abroad by their bank for, it'll be rare that they're intending to go for the rest of their lives. Your point is temporary and time limited.
Yes.
Temporary and time limited, and all the other things as well.
Yes.
Because, I mean, if that's what Lord Wilson thought we would have had, temporary and time limit, that would have come in there. But what he's just talking about, somebody who goes abroad on work, which is a perfectly ordinary thing. It happens a lot.
Yes.
And you would normally expect those people to come back to the UK after the police abroad. That would be within your contemplation. So it's other factors as well that you bring in about the quality or the nature of the deployment abroad.
Yes.
Is that right? That's your case.
And although, of course, we're looking at this case for the statements of principle, one does need to bear in mind the kind of fact situation they had in mind, which one sees sufficiently from the headnote. In the first case, the taxpayers moved to Belgium to work full-time, but neither sold their homes in Wales, where their wives remained, and they had local connections, and they each returned frequently.
Yes.
And in the second case, likewise, someone moves to the Seychelles, travels the world on business, but continues to maintain a house in England which he used frequently. Yes. So these are very different factual situations from that with which we're concerned here.
Yes, and that is one of the reasons that the appellant seeks guidance if the court felt that it wished to give guidance in relation to members of the
appellant seeks a result in his favour. I mean, which will inevitably involve a degree of guidance, though how relevant that guidance will be given that we're no longer subject to the Brussels regime, is rather doubtful, isn't it?
Well,
are there hidden implications?
It's still important to determine residence for jurisdictional purposes. Because we're still looking at establishing jurisdiction, even after Brussels. It may be that once I've read the Travaux Preparatoires, I have a different answer to that question, but there is still a need to establish residence for jurisdiction.
But anyway, perhaps the only point I was making is it's slightly odd to say you want a result in your favour.
Yes.
That may or may not produce guidance, but
well,
you're not in a period of representative capacity for
no
other people. No.
I had thought that we were looking at this case because the issue of residence comes up within the issue of domicile, which is tied to Section 1, or the order, which is all part of the EU mechanism.
Yes.
And that once we've left the EU, that mechanism falls over.
Yes.
You say there's a read across, however, from this case to post-Brexit, and that we need to look at it more broadly.
This is the context in which we're looking at it. But
why do we need? I'm cautious saying this is my lord and my lady know more about this area than I do. But in a purely common law situation, why is residence relevant for jurisdictional purposes in a post-Brussels world?
May I turn my back? I'm terribly sorry.
Yeah, exactly.
Yes, I'm terribly sorry to turn my back on.
No.
But my junior, of course, has the answer to that question, which is that it still remains relevant in relation to consumer contracts and employment contracts, because there's a saving where, in cases which would have fallen under recast Brussels previously, there is a carve out. Effectively,
well, that's sections 15B and C.
Yes, that's right. Yes. Okay. Well, that's well done. That is, and I'm always assuming that they effectively. I knew they introduced a new regime, but the substance of the new regime is the same as the Brussels regime, is it?
Yes, 15.
Oh, yeah. And uses the language of residence.
I think it's 15A. If I could use this iPad, I'd be able to tell you.
Oh, I see. Yes.
Harks back to RICO. It refers back to cases which would have been covered.
No. Well, assuming that's right, then that is a good answer. I just
It's a
haven't
very
had to
good
look
answer.
at 15B or C. Okay.
Yes, I think I had dealt with Davis. There are various places in which all the principles are brought together, but perhaps the first most authoritative one is Bestelov, and that's the one that the learned district judge referred to. And in Bestelov, the point is made that it is possible to have more than one residence, and that for jurisdictional purposes it needn't be the principal residence.
Well, hang on. Now, we've looked at all. Have we now looked at all the cases by which we are banned?
Yes.
So what we have here is a series of first instance decisions. I'm the worst for that, of course. But what they mostly do is just look at the same authorities we've looked at and extract a lot of propositions for them with an eye on the particular point in their case.
Precisely. But Bestelov, I don't propose to take you to the others, other than Chowdhury, but Bestelov does set out the principles, distills and sets out the principles which have been followed and are being followed.
Well, the possible exception to my Lord's point is that in the judgment of Mr. Justice Singh as he then was, there is a reference to the Court of Appeal decision in Fox and Stirk and to what Lord Denning and Lord Justice Widgery said in that, pages 84 and 85 of our bundle. So there are at least some Court of Appeal dicta, and speaking for myself, I found the passage from Lord Justice Widgery's judgment at page 85, paragraph 27. And this is a citation from Fox and Stirk, to be of some interest. I say that to you so you can make any submissions you want to about it.
My lord, yes, this is Panagaki, the healthcare one, where the claimant was in hospital, effectively.
Well, Panagaki was.
Yes, Fox and Stirk was a voting case.
Yes. So paragraph 27.
But it's really what's said generally at paragraph 27 about what was meant by what Viscount Cave was saying in Levine and some other authorities which refer to a residence as being where a man lives and has his home. Those were the...
Yes. But I would emphasise not the word lives, but the word home. As I said earlier, Mr. Stait considers England to be his home. And I would also emphasise...
Well, hang on. Surely his home, while during that 5-year posting, was in Cyprus, or more accurately in the SBA.
The evidence is that because he bore in mind that his absence was only temporary and they always had an intention to return, that I say England's his home. But I would also emphasise...
Well, I can understand you say his home country rather than his home place of abode. I mean, I'm sure when his wife said to him, I'll see you when you get back home this evening, when he was on the base, she didn't think she would see him in Cumbria.
No, but it may be, yes.
I mean, yeah, and home, all these words have unsatisfactory other possible uses.
Yeah.
But if you asked him, where are you living, which is actually one of the tests mentioned in Levine, when the dictionary thing, if he didn't know what the consequences of this answer would be, he would certainly say, well, I'm living in Cyprus.
Yes.
He might say, if it was relevant, but I'm not going to be here forever. I'm not going to be living here forever, because I used to live in England, and that's where I'd like to live when I come back from Cyprus. But where he's living is pretty obviously Cyprus, isn't it?
Yes, that's what he
Whereas he
might
wouldn't
is
say
where-
that if he was in the on a short-term contract, living in Nicosia or indeed on the base, and staying in a hotel or even a rented flat. Where are you living? Well, I live in London or Cumbria, but just at the moment I'm doing a job in so living in a hotel. That's a very different sort of answer than where are you living in the sense one normally asks that question.
Yes, it would depend on the context in which the question was asked, I suspect. And one can readily see that when he flew back to the UK during the period between 2016 and 2021, when he set foot at Gatwick or wherever it may be, he might well say it's nice to be home.
Yes. I've just noticed, I'm glad my Lord took us to this, because I think Shelton's also picked up this concept of permanence, which worried me slightly, because it seemed to me you could be resident somewhere without being permanently there, whatever exactly permanently means. But it's quite clear that permanent itself is referred to as a relative term. It talks about a degree of permanence.
Yeah.
And permanence is contrasted to a short temporary visit.
Yes. So,
Yeah.
I mean, that's the other thing that I would draw from this. It's imperative to remember that residence implies a degree of permanence.
A degree of
Equals
permanence,
a considerable
yes.
time. So there's then permanence, something which will go on for a considerable time, short temporary visits, and that's why I emphasise the temporary and time-limited nature of the posting. So some assumption of permanence, some degree of continuity, and there's no degree of continuity in this case because.
Well, he's there. There's a huge degree of continuity for the 5-year period.
No.
He's there all the time, except for going back a week at a time, or maybe 2 weeks at a time to for a holiday in England.
For that period, there is.
It all comes back to, really, doesn't it, whether we look beyond the confines of that period.
Yes.
Yeah.
Which I say you should on the authorities, and in particular the parts of Levine to which I've taken you. But some expectation. Sorry.
If one's just trying to take a period, is the period we should be concerned with something which is in some way tied to or referable to the period in which litigation might be concluded, since we're here in the context of where litigation should take place?
There's no authority for that proposition. No. There's no consideration of that, and I think it might give rise to some quite odd results because that would depend on the applicable law. So, for example, you'd look at a 10-year period in France, but you'd look at a 6-month period in the Dominican Republic because those are the relevant limitation periods.
No, I'm not talking about limitation. I'm talking about under the Brussels regime since the convention and all the way through the two regulations. What we're concerned with in insurance cases is giving an assured, an additional right of suit at the place of his or her domicile, additional to the general rules in relation to tort and the place of domicile of the defendant. And as I understand it, the rationale behind that is because assureds, like consumers and employees, are put in a particular category of vulnerable people, and therefore in the rather mechanistic way in which the Brussels regime works, they are deemed to be less sophisticated and more vulnerable, and therefore less able to conduct litigation abroad, if I can put it broadly. Now, if that's the context in which this additional gateway of jurisdiction, of domicile, arises, and for domicile we're now looking at residence under the English definition, it might suggest that we're looking at the sort of periods which litigation might take, not limitation periods, but how long litigation might take. Now, of course, it's not going to be exact. It may be that you're at the beginning or at the end of your stay, and the litigation may be after you were intending to come back, or it might be all when you're intending to be there. But just as a sort of one of the factors one might have in mind as to whether we're looking at a period of 2 years, 5 years, 10 years, 20 years, is it relevant to bear in mind that what we're really concerned with is the ability of a vulnerable person to conduct litigation abroad. Abroad in the sense of somewhere where he's not living.
Yes, but I'm slightly cautious about that because it's quite easy for that to shade over into sort of an argument of forum conveniens, which has no place here, and the potential problem with that is that a similar problem will arise in relation as it does in relation to limitation periods, because different jurisdictions will take different times. So, I mean, Lady Brownlee's been waiting for a decade for her case to get up and running.
Maybe the result of some interlocutory litigation.
But that my lord has, as it were, catered for that objection by saying one's not talking about individual cases where it clearly won't help. As he said, what if the day before you were due to go back, you started your litigation? Perhaps you had to because of limitation periods or whatever. So in practice, his point, however, is that you've got to look at the broad scheme of the regulation, which is rather mechanistic. It basically says if you're in this vulnerable category, you have this extra right. Sometimes this extra right will be very valuable to you. Sometimes it won't really make much difference. Might even be unhelpful. But in understanding the terms of the scheme, that's what you've got to look at. I can put that very well.
And you're not, my point essentially is, if you had a case in which you could be expected to be in the place where you have to litigate in the defendant's domicile for the duration of that litigation, you wouldn't fall within the vulnerable category at all, or probably not. So if you were stationed to Cyprus for 20 years, and let us assume that every reasonable expectation would be that within 20 years of an accident, or at least within a few years of an accident, the litigation would be concluded or compromised, then you wouldn't be in the vulnerable category if you were going to be physically present at an airbase in that place at that time. I suspect with probably some sort of administrative support from the forces there to help you litigate there.
Yes. I mean, that would certainly be a purposive approach that would be consistent with interpretation of the regulation and how it ought to be interpreted. So to that degree, I accept that. I'm just trying to think. Quite a lot would then depend, though, on when the accident or the event giving rise to the claim occurs in the course of one's posting, for example.
It would, and that can't affect the question of what the relevant period is for determining residence. So this is imperfect, but it is also the case that the Brussels regime is notoriously imperfect and mechanistic in its allocation of jurisdiction, but that in this case, any potential injustice or difficulties in extreme cases is mitigated by the fact that it doesn't remove the ability to sue. There are other rights to sue under the different jurisdictional bases. Anyway, there we are.
True.
I floated that, and you may want to think about it, but it's just something that was going through my mind.
Oh, I wonder whether, though, it raises this issue because you might have a 20-year posting, and the accident might happen 2 years from the end of it, and it would be, the limitation period might be 10 years, for example. You'd still be in that vulnerable position for 8 of those years, for example, because you've got 2 years of the posting and then you're coming back. So it does interlink with the limitation period, because it's not reasonable to anticipate that a claimant will bring their claim immediately after the accident. So in terms of consideration of how long they're going to be posted and be in that vulnerable position, you have to take the limitation period into account, I think.
Well,
I
I'm
think
not sure I would agree with that, but I'm not sure that's going to advance the
If my Lord's point is a good one at all, it's a very broad brush point.
Yes.
It's not tied to particular circumstances of particular individuals or particular jurisdictions.
I think the answer to the question, now that I'm thinking it through, is that I accept that that is an appropriate purposive approach, but that I have concerns about how it would work in practice for the reasons I've given.
Yes. So we got onto all this, I think, from looking at the passage in Forts and Sturck, from Forts and Sturck, quoted in Panagaki.
Yes.
You actually, I think, well, not yourself wanted to taste Panagaki. It's we who took you to that passage.
Yes.
You wanted to go to Bestalon.
Before we leave Panagaki,
Oh, yeah.
as we're there, again, I would emphasise the last sentence in the passage quoted. Some assumption of permanence, some degree of continuity, some expectation of continuity is a vital factor which turns simple occupation into residence. And that's the distinction that I seek to draw here, occupation and residence. And an expectation of continuity there.
Yes.
And actually, Panagaki, as we're there in Panagaki, in that case, the learned judge accepted that mere physical presence in a hospital in England did not lead to residence.
That's a very different, that doesn't cast much light. It's an interesting case.
No, but
it doesn't cast much light on the issues for us, does it?
No, but it just is perhaps a little brick in the wall to support my physical presence does not equal residence argument, perhaps. But Bestalov, and yes, this is not, of course, binding on this court, but it is, I say, helpful to look at it because it distills the principles into one helpful place.
Sorry, I missed that. Why is it helpful to look at it?
Because it distills the principles into one helpful place.
Yes, I see, yeah.
There is reference there. If you would look at page 103, I'm going to take this very briefly because I have made this point previously, but it's paragraph 28. Point of some potential significance in the present case that it's possible for a defendant to reside in more than one jurisdiction at the same time, and it's possible for England to be a jurisdiction in which a defendant resides, even if it's not his principal place of residence, i.e. even if he spends most of the year in another jurisdiction. But the principles derived in that case and which are being relied upon, and this is a case that is routinely relied upon in jurisdictions.
Sorry, can you speak up a little?
Sorry. This is a case which is routinely relied upon in jurisdictional challenges. So
I'm saying nothing rude about Mr. Justice Bryan. That is sometimes because practitioners just love to go to cases which just purport to distill all the case law.
Absolutely.
That doesn't necessarily mean it's the right thing to do, particularly in a case where we're having to decide for ourselves. But anyway, by all means.
I don't refer to it because it's binding on you. It's not, but it for the court's information, I suppose, that this is the way these cases are being approached.
You say it's an accurate summary of the law.
Yes. It's at page 111 and a much repeated list of propositions. And I have taken the court to the underpinnings of these propositions, in particularly Levine, but also Davis. First of all, it's possible for a defendant to reside in more than one jurisdiction at the same time, which is the point that I rely on. Secondly, it's possible for England to be a jurisdiction in which a defendant resides, even if it's not his principal place of residence, even if he spends most of the year in another jurisdiction. I rely on that as well. Thirdly, a person will be resident in England if England is for him a settled or usual place of abode, which I say is the case here. And a settled or usual place of abode connotes some degree of permanence or continuity, which again I say is the case here. Fourthly, residence is not to be judged according to a numbers game, so you don't just add up the days and decide where he spends most of his time. And it's appropriate to address the quality and nature of a defendant's visits to the jurisdiction. Fifthly, whether a defendant's use of a property characterises it as his or her residence, that is to say, the defendant can fairly be described as residing there, is a question of fact and degree. But to that I would add, but there is a right answer to it. Sorry. Sixthly, in deciding whether a defendant is resident here, regard should be had to any settled pattern of the defendant's life in terms of his presence in England and the reasons for the same. So you can look at why he's here or not here.
This is all formulated, of course, we're having in mind cases where a defendant is being...
Yes.
Who can plausibly say, I don't live here, may nevertheless be regarded as living here.
Yes. But the same factors and considerations apply the other way round.
But subparagraph 6 is rather contrary to what you were submitting earlier in the context of a distinct break from a settled pattern. Because what Mr. Justice Brown, or Sir Simon Brown, or Simon Brown QC as he then was saying, was you have regard to a settled pattern of life in terms of presence in England. Whereas you were suggesting, for the purposes of identifying whether there was a distinct break in the pattern of life, what pattern meant was not presence, but connecting factors. So has he got that one wrong?
No, he's right about that. But presence is considered, I submit that presence is considered in the wider sense of presence. So he's got a presence. He
hasn't got a presence.
Well, I've got a presence at my house now. I'm not there, but I have a presence there.
Do you?
It's another one of those words like home, which has a narrow and a broad meaning, and I contend for the broader meaning.
In the jurisdictional context, presence tends to mean physical presence. He was not physically present in England except on his annual short holiday visits. That's the only time he's physically present.
Presence can mean wider presence, in my submission, and does in this context. And these lots. Bestelov is one of the oligarch cases, and it is the other way around. So, establishing residence of a defendant. But if a defendant visits a property in England on a regular basis for not inconsiderable periods of time, where his wife and children live in order to see his wife and children, including where the centre of the defendant's relationship with his children is England, such property has the potential to be regarded as the family home or his home when in England, which itself is evidence which may go towards supporting the conclusion that England is for him a settled place or usual place of abode, and that he is resident in England, albeit that ultimately it is a question of fact and degree. The oligarch cases are slightly different because they have a lifestyle which is different to the lifestyle of a member of the armed forces. I hope that's not controversial. Albeit ultimately it's a question of fact and degree whether he's resident here or not, having regard to all the facts of the case, including any discernible settled pattern of the defendant's life, or as it's been put, according to the way in which a man's life is usually ordered. And again, I would make the point that what is usually ordered has to be considered against the backdrop of a longer rather than a shorter chronology. But I accept that if the court is inclined to take the shorter chronology, i.e. from 2016, this is not a factor which goes in my favour. The other case which I say is of interest in this context, although again not binding, is the Chowdhury case, which is at page 221. And Chowdhury was not an oligarch case, it was a more similar case to ours, where it was a British claimant who was injured in a road traffic accident in Poland, but by the time the claim was issued, he had gone to Germany for the purposes of his health. So he was living in Germany and didn't have a physical presence in the narrower term in England at the time the claim was issued. And he was nevertheless held to be resident within this jurisdiction at the time the claim was issued. The learned judge in that case...
Just give us...
Sorry.
I did read this last night, but where at the relevant time, in what sense was he living in Germany? Where was he living in?
He had a rented flat on a short-term rent, or short-term lease.
And how long had he been there?
Some years from recollection, I'm sorry.
I thought it wasn't as long as that. But...
Yeah, so April 2018. This is at page 225, paragraph.
Yes, here we are. Yes, that's right. The relevant date is 25th of August 2020.
Yes.
He left England in March 2018, so the total period of absence from England is 2.5 years.
Yes.
As for the character of the trip, the first is to go to Belgium for treatment, not quite clear where. Then he moves to Germany to another hospital. And then he moves out of the hospital, but continues to be under the care of that hospital, and rents accommodation nearby. And then he is there for quite a long period. Yeah, okay.
Yeah.
Thank you.
So that's the background to it. And the learned judge has taken to the cases which your ladyship have been taken to today, and sets out his analysis of them, which is of interest in our case, in my submission, because it's more. This case is more similar to our case than the oligarch cases. So page 228, this is the question of how long you look at when you're considering the different factors. So paragraph 37, where the learned judge says, domicile is to be determined as at the date when the action of the claimant in this case was issued, August 2020, but what is the scope of the evidential timescale which should be considered? All of the cases set out below on domicile and residence contain a
Right,
careful
this first paragraph is self-evident.
Yes.
Yeah.
It's not the actual date of issue, and the mere physical presence and actions of a claimant on that day are not the determinant of domicile. So you're not just looking at the day, you're looking at a longer period than that. And then at 230, paragraph 44, he refers to the example of the master mariner, which we've looked at in Levine, and says residence in England is not lost merely by reason of travel, even long duration travel due to work. And we say that this is that type of situation.
But this is very different from the master mariner case. The master mariner case goes out on a voyage and comes home after each voyage to his home. And I think the example given is certainly within a year, and anyway that would normally be the case.
I accept that it's different because he's continually moving during that period.
Well, he comes
home more. I think
he comes home to the home where his wife and family have been all the time.
Yes, I do accept that there is a distinction there, but it is nevertheless helpful to consider a case where a person does not have a physical presence.
Anyway, where are we going now?
And if you said, well, where are you living? He'd say, well, I'm living on board ship, but he would still be resident at the.
I'm not sure. I think you'd more likely to say, where, especially if people knew he was a sailor, they'd say, where do you live? He wouldn't say, I live on board ship. He'd say, well, I live in Hull, but I go away on my trips. Anyway, there you are.
Well, in terms of seafarers, voyages...
I don't think seafarers are a very good analogy.
They're not going to help us, I don't think. But 234 is, I say, quite useful. Paragraph 64, interesting. Paragraph 64, where he says mere ownership of property is not determinant. And we've seen that in Levine because it was hotel trips. So the obverse must be true. Mere lack of ownership of property does not abolish residence in England. And then and this is really why I take the court to this authority, because at paragraph 78, which is the last but one page, page 237, the learned judge sets out his rationale or a rationale as to why that should be so, where he says, turning to the ownership of property or the rental thereof, the master took into account the claimant did not rent or own any property in England at the time of issuing the action. But that is not determinative in law, and I so rule.
We'll just read it to ourselves.
Sorry.
Yep.
And the point I make about that is that this claimant didn't give up ownership of his property. He maintained his property. He gave up living there, but not because he wished to move his life to Cyprus, but because he was posted in Cyprus for a temporary and time-limited period. So that's the rationale behind what he did. And I say that it is relevant, just as intention is relevant, so is the rationale behind what he does that takes him out of this jurisdiction is also relevant.
Yes.
That takes me to the end of my consideration of the authorities, and as I've been going through them, I've been, hopefully, commenting on them as to why I take you to those particular passages. You have indicated that you would not find it helpful for me to take you through the judgment.
Well, I didn't mean to say we shouldn't look at it at all, but I was merely indicating I think the answer to the case is not going to be found in a detailed analysis of exactly how the judge dealt with particular factors. But you could obviously, I'm trying to stop you making whatever submissions you want.
Well, if I can take you to the judgment very briefly.
Yeah.
And against the backdrop, and I have made the points going through the authorities that I would make in relation to the judgment, we say that although the learned judge heard these...
I'm sorry, I'm just following up on a point you made earlier.
Sorry.
Just, if you'll forgive me, taking you back to it. It was the suggestion that I think you made, but I may have misheard you, that it was always his intention to come back to Cumbria to live back at the home that he'd owned in Cumbria. Now, I wasn't quite sure what the evidential basis for that was. He'd been stationed, he'd grown up in Gloucestershire, as I understand. He'd been stationed in various different places. He had bought the Cumbrian property when he was stationed nearby. He'd gone to Cyprus, and he does say that they rented it out and kept it because it was his intention to return to the UK. That's not quite the same as saying that it was his intention to come and live in Cumbria. And if the previous pattern of his service life had continued, I don't suppose he would have lived in it, or his family would. He'd have had them with him on accommodation on whichever base he'd been sent to within the country, or indeed abroad if that had happened.
There is an answer to that, which is that he's now back in the UK. I don't know whether he's living in the Cumbria house or not, I hasten to add, but there will be an answer to it. But...
Well, that's my point. You're perfectly entitled to say he kept it because he intended to come back to the UK.
Yes.
What I was questioning was your submission, which I'd understood was your submission, that it was his home, and it was a home to which he intended to return to live.
Well, he does
when
say...
he came back to the UK. Does he say that?
So he does say it, paragraph 8, and I say it's a reasonable inference that is the case.
Sorry, let me just find the fact. We didn't have the witness statement, but it was sent to us later. Yeah, I've got it now, yeah.
Yeah, paragraph 8 was the passage I had in mind.
Yes.
We knew we'd be returning to the UK, so we kept our house.
Yes. And that, I say, gives rise to an inference that because he knew he was coming to the UK, otherwise the two things don't...
But unless he'd left the RAF, he might have found himself posted to Yeovil, or...
He might.
No particular reason to believe he'd be posted back to Cumbria at all.
No. But the inference from what he's saying there is, we kept the house because we knew we were coming back.
Well, it's certainly, it's not an inference, it's a statement that he came back to the UK, but it's not a statement he came back to live in that house.
No, but what he is saying is we kept the house because we were coming back. And wherever he might have been posted, certainly his understanding or intention seems to be, we knew we'd come back to the UK in 2021, and therefore we kept a property, which is consonant with him wanting to live in it, because actually when he was away and not living with it, he also kept it. So it's the word "so" there that I say is doing some lifting, because otherwise he would just say, our time in Cyprus was always going to be on a contract basis, and we knew we'd be returning to the UK. There's no, if they don't intend to live in the house, there's no juxtaposition between returning and keeping the house. There's no reason to link the two, unless he thought he was coming back to live there.
He doesn't actually say, but you say this was a reasonable inference, that he lived in the house before he went to Cyprus, does he? Simply says they own a house in Cumbria.
He doesn't, but he's on the...
He says he met his wife in Cumbria.
Yeah.
Is that, forgive my ignorance,
He's
is that
living
where
in
RAF
Scampton.
Spadidan is?
Yeah.
Right. And RAF
married.
Scampton somewhere else, is it?
He was at Scampton just before he went to the SBA.
Yes.
No, where's
And I
Scampton?
had not understood Scampton to be in the same place as... Maybe I'm wrong, maybe it is in Cumbria.
Scampton's in Lincolnshire, my junior tells me.
Yes. Well,
So probably not living in the Cumbrian house immediately before he went to...
Not immediately before, no.
No, not for the 3 years before.
it's not impossible on this evidence. That they bought the house at some point between 2007 and 2013, but maybe towards the back end of that period, and never actually lived there because they knew they would. We just don't know. It doesn't tell us.
It doesn't tell us.
Okay.
It doesn't tell us.
No, I mean, it's consistent with this, that was never a home in a sense of a place where they ever lived.
That's a possibility.
It may just have been a UK investment that had always been rented out.
That's a possibility on the evidence.
Thank you. Sorry,
But he is on the electoral roll.
Well,
So
he says that, but again, he just says, I am on the elect. He doesn't say where, and he doesn't say on what basis. Just,
no.
I've always thought it was to do with residence. You have to say I'm resident
Yeah.
somewhere, in which case you couldn't truthfully, I would have thought, have said it in the sense, at least in which it's normally understood. Each year he'd have to put in a return saying who's living in the house. He couldn't very well say he's resident on that basis. Most likely, as my lord says, there's some special provision for, must be special provision for people to be on the electoral register if they're serving the forces overseas, and that's fine. I don't think there's a problem there, but I don't think it helps on the points we're looking at now, except the point he wants to go on voting in Britain.
Yeah. I'm sorry, I just can't help.
No, well, I can't hear beyond the evidence.
That's what we've got.
Right.
Sorry, I distracted you.
You were going to take us to the judgment.
So, very briefly, as I say, this is at page 55 of the core bundle. So if I can put it this way, the Best-Loff principles are set out at paragraph 13 of the judgment. But then we say he doesn't then follow the principles through. And at page 56, he begins his analysis. And distinguishes Best-Loff. But the point about Best-Loff is that Mr. Best-Loff was a Russian national whose only link to England and Wales was his visits to this jurisdiction, to his family. So the judge saying, well, that's a different scenario to this case, where he only comes here once a year. What he's not doing at paragraph 18, where he says he only comes here once a year, is taking into account all of the other factors.
Oh, yes, but come on. 18 simply says, no doubt you, having perfectly reasonably placed a lot of weight on Best-Loff, that he finds Best-Loff factually very different, which is obviously right.
Yes.
And then he goes on at 19 saying, nevertheless, I do need to consider all the circumstances. So I don't think you can criticise 18, can you?
Well, he does, but then he says at 19, when he's looking at it, it cannot be said that my submission below was it cannot be said that he's abandoned his residence. And he says, I don't accept this as the correct way of looking at it. It's for the claimant to satisfy me he resides in England rather than establishing a negative that he's failed to abandon residence. And I say that's wrong on the authorities, because although the burden of proof is on the claimant at all times, there is a distinction between people who have proven that they were resident before a certain time. And this is a man with an absolute rock-solid basis of evidence that he was resident in England and Wales before 2016. So I say that the judge should have looked at it, asking himself whether or not that period of time before 2016 had been negated in some way. But he doesn't.
So if in his witness statement he hadn't dealt with anything at all that had happened after October 2016, and had simply given evidence of what the position was up until that moment, that would be insufficient, would it? No burden of proof on him to establish residence thereafter, and he could say, well, there wasn't any evidence that I'd abandoned that residence.
Well, you could draw an inference from the fact that he doesn't provide any evidence for the last, between 2016 and 2020. So the burden, because the burden of proof remains on him to show what's happening at the time of issue, and if he gave no evidence as to what was happening at the time of issue, you could draw an inference that there was no evidence to be given. So, no, I say.
It's not the burden of proof that's the issue, it's the test. You say the judge got the test wrong here. Because what you're looking for is, I can't remember what the catchphrase is, but it's a break with what had gone before.
Yes.
And so your submission is that that's what he needed to be looking for.
Exactly, but he confuses the burden of proof with that test, because he's saying because it's for you to prove residence, therefore the test is not abandonment of residence. And that, in my submission, is wrong in law. He then at paragraph 20, over the page, at page 57, says at paragraph 20 at the end, the house cannot be regarded as his abode. And I say that's wrong too, and that you can regard the house as being his abode because he still owns it. And I say, well, I accept this as a matter of inference. I say he intends to return to it. He then says at 21, there's no evidence that any other place he'd be entitled to live in or could be classed as a base for any kind of settled pattern of life. I say that's not necessary. I didn't need to prove that on the authorities. Because if, for example, one showed an intention to return to the Savoy Hotel and other hotels, that would be good enough. But it wouldn't be. It wouldn't have satisfied this judge because he wants a base identified prior to return. He then, later on in that paragraph, speaks about Cyprus. He says he did have a settled pattern of life in England until he moved to Cyprus. Once he moved there, he ceased to be resident in England or indeed the United Kingdom. He may at some point re-establish a pattern of life in England. The evidence was that he was going to, and that is his stated intention. It's both uncertain on the evidence, and in my submission that's not right because the intention was to return. And he said our time in Cyprus was always going to be temporary, and we knew we'd be coming back. And irrelevant to the question of whether he had one at the relevant time. Now, his intention is not irrelevant, and I hope that I've established that in the authorities that I've taken you to. His intention is explicitly said to be relevant. But at no point does he consider in that paragraph whether or not there is a dual residence here. He says when he goes to Cyprus, he ceases to be resident in England, but he doesn't say why. It may be that the learned judge was right, that when he went to Cyprus, he became resident at the base. But there's no consideration of whether or not that was in addition to his residence in England and Wales. And there's no analysis as to why he concludes that there has been an abandonment of English residence. And then in relation to the consequences of his findings, that's set out at paragraph 24, where he says, I was making submissions in relation to the armed forces question, and he says, of course, I have found he was not resident for jurisdictional purposes as a matter of law on the facts of this case, so he cannot be said to have lost what he never had. He had a right to sue in the courts of his own domicile as a vulnerable person that he lost as a result of the finding that he was not resident in this jurisdiction. And I say that that comment betrays a misunderstanding of what this case is about, because as a consequence of this finding, he has lost something. He's lost something of value, which is his jurisdictional rights as one of those people in the category of vulnerable people. So he does lose something, and he loses something of important value.
This goes to the point of which you make quite a lot in your skeleton arguments, that you would say Mr. Stait is very prejudiced by the DJ's decision. I just wanted to understand what that prejudice amounted to.
Yes.
Is the structure of paragraph 24 of what the DJ says, is that actually right? He has still got a right to sue, as you've discussed with my lord.
Yes.
He can sue in Cyprus.
Yes.
He just can't sue in the UK.
Yes.
And I mean, Cyprus is a member of the EU. The UK was a member of the EU at the time. is there any additional prejudice that we should be thinking about of how this is going to impact on this individual?
Well, the rationale behind giving him this additional right to sue in his home domicile is, as I discussed with his lordship, that it's thought to be that he is in a particular category of particularly vulnerable people.
It's that point.
And it's that point.
It's that point. Provides support to somebody who might be in a vulnerable category.
Precisely.
That's it.
Yeah.
That's the long and the short of it.
Yeah, it is.
And there might be others who fall more obviously into that category than him. I mean, this is a Cypriot law claim, in which whether he would have to give evidence himself, maybe he might or he might not need to do so, but it might be the case that had he brought proceedings in Cyprus within, let's say, a year of the accident, which might not have been thought of as unreasonable, even though the limitation period hadn't expired, he could have conducted the litigation there with the benefit of support from those on the base and had it concluded by judgment or compromise before he came back. So it may be that his isn't a case, actually, where he's been prejudiced at all, although there would be others that might.
Well, I mean, he will be prejudiced now because he's brought it in this jurisdiction, and it may be that it would be much more difficult for him to bring it in the Cypriot jurisdiction now, because now we're considering it, he's back.
Well, but that's the consequence of having sued in the wrong place.
It is.
If that's
what's
result.
happened. But whatever the decision that this court makes about that and about whether he's lost something, it will apply equally to those people who might have had a claim in Iraq, for example, or Afghanistan, where it might be very much more difficult to bring a claim, particularly as a member of the British Armed Forces. So although we happen to be talking about...
Hang on, I mean, so what's that got to do with it? We're dealing only with countries subject to the Brussels regime.
Yes, you're right. It wouldn't be.
So that's really important, actually, because we have, we can all have other jurisdictions in mind where it might be very different. But this is you're talking about your EU jurisdictions and where you bring your claim, and that's the long and the short of this case, isn't it?
Yes, you're right. Yeah, I'm just thinking that through. Yeah, I mean there will be some prejudice, or maybe some prejudice in some countries, because the cost rules are different in some nations.
Yeah,
so you can't get funding.
There are all sorts of reasons why it's...
But your case was always going to be governed by Cypriot law anyway, wasn't it? So the framework of the case would have been the same, whether it was UK, whether you brought it, assuming you were permitted to, in the UK or in Cyprus. The law applicable, I don't know about costs, I'm afraid, but the law applicable will be the same.
The law applicable would be the same, so the limitation period and so on would be Cypriot, but the cost rules and rules of procedure would be English, because we're in the English forum, whereas they would be Cypriot in Cyprus, because it's the rules of the forum that apply, including costs, and in quite a lot of...
But the principle underlying the entire Brussels regime and the membership of the European Union is that all courts are treated as of equal value.
Yes.
And that any differences in procedural rules must be ignored in terms of where the justice is in where the person brings their claim. So that as far as I'm concerned, it's only the special provisions in Brussels Recast which deal with assureds and employees and consumers to deal with their particular vulnerability, which is something of which he is potentially within a class of those being deprived of the protection against those vulnerabilities.
And on analysis, that is the increased difficulties of litigating in a country which is not your domicile.
Yes.
Not because of any difference in the substantive or procedural law, because my lord says that's off limits, just to have said those are all the same, but simply the fact that you're in country A having to deal with an unfamiliar jurisdiction 1,000 miles away.
Yes.
Or
It's really it's the difficulties in giving evidence and instructing lawyers in a foreign legal system, coupled with the fact that if the defendant is domiciled there, the defendant's on its own turf, and that's an imbalance between an individual and what is often a corporate entity.
Yes.
Those essentially are the sort of vulnerability factors that Articles 11 and 15 are protecting against in the case of assureds and victims who are claiming against insurers.
But that's what he's lost, and he has lost.
But he wouldn't have lost that if he'd been on the base at the time that he brought his action there. Really, would he?
There's no evidence about that, and even if there were, it's something that I would say that the court shouldn't take into account, because.
But all I'm saying is it's an individual thing. I mean, one can certainly conceive of cases where an individual would be prejudiced by having the accident the day before they came home or whatever. But if we're looking at whether it's operating unfairly on your client in particular, it might not. It's not necessary. It's not obvious. But surely it's necessarily so.
Yes.
Is that fair?
Yes. Yes.
But surely, with respect, the fact that it operates unfairly on your particular client is something we had to put out of our minds, isn't it? If you have a point at all, it's about the correct approach to a question of construction.
Yes.
On facts of this kind, or how it applies in circumstances of this kind generally, and therefore we can only be concerned with the inherent vulnerabilities, rather than with a particular vulnerability in this case. And my lord points out, actually he was resident in, he could have brought proceedings quite easily in Cyprus within a year. You'll no doubt say, oh yes, but he'd had an operation and all that. But all that must be irrelevant, mustn't it? Because it's a question of construction. It's not a question of a discretion about what does justice in the particular case.
No. And I'm expressing myself poorly if I'm giving the court the impression that that's what I mean to argue. It's not about that. The only point I make about this is that the learned judge thought that he hadn't lost anything. He has lost something because he's lost the jurisdictional rights associated with being a vulnerable person. And I do endorse the fact that any particular vulnerability should not be taken into account.
Okay.
But also, the fact that he may not be a particularly vulnerable person shouldn't be taken into account either.
Yeah.
The fact that he might have support.
I brought the point. Well, now I see the time. It would be very neat, provided we put you under appropriate pressure, if you were able to conclude your submissions in the next 3 or 4 minutes. And I thought you probably could, as always happens. You've effectively made them in response to our questions and in response to your exposition of the law. What more do you need to say?
Nothing, I think. So it's safe to return to the point that I have been making, if I may. This may be repetitious, but just to say that because he is a member of the armed forces, there are particular. There is a peculiarity about his position which distinguishes him from others, due to the nature of why he leaves the jurisdiction, but also because of his work, he has particular ties to the jurisdiction, which are peculiar to members of the armed forces because they're tied to this jurisdiction in a way that people who work for, HSBC and are posted abroad might not be, because he's working for the Queen.
Thank you. Well, the 2 points which you may want to come back to, and although I said you could do it in reply absolutely formally, if you have positive points you want to make about the travaux préparatoires, they are better made immediately after lunch, because if they're part of your case, I'm sure we'll cope if you need a bit more time, and therefore need to deal with in the reply. The other point is really just to spell out to us exactly the route by which these provisions actually apply, the ones we've been looking at. It doesn't appear to be Section 41 as such.
I think I may be able to square that circle and hopefully save and learn a friend
why
a
not?
bit of research over the lunch break.
Yes, have a go.
Which is, my Lady Justice Whipple referred to the fact that the 2001 order obviously predates, as it does, the 2012 regulation. We have the, as ever, snappily named Civil Jurisdiction and Judgments Amendments Regulations 2014, Schedule 2, Paragraph 2 substitutes within the 2001 order the reference to regulation to mean the recast.
You want the recast Brussels. So,
Yeah.
can you give me the reference?
Of
Have you got an SI number with you?
I don't, my lady.
But it's the 2014 amendment regs.
The 2014 amendments. It's SI 2947 of 2014.
Well, that sounds as though that's the answer, Mr. Mackenzie. Well done. I think that my lady is so diligent she may anyway look over lunch, but
I'm going to spare you. I can look that one up, so you'll have other things to do, I expect.
all the same, I wouldn't mind having just hard copies of both regs. So we actually haven't got 2001 either, which should be possible for one or other of you to do by 2 o'clock.
The other thing I was going to offer over lunch, my Lord Justice Popplewell asked about the status of the convention and then the regulations vis-a-vis the SBA itself. There is an answer to that. We haven't put it for you. Set up my skeleton at first instance. That would be quite easy to, again, produce over the lunch break a copy of for the court.
Terrific. That would be very helpful. Well, thank you very much, Ms. Prager, both for the substance and manner of your submissions, and also for finishing them so neatly at 1 o'clock. You're unlikely to be all afternoon, I suspect, as we've been exposed to the older case law already. So I'll be surprised if we're still here at the end of the day. Thank you.